Thanks so much for the intro again and the kind words. Thank you again also for the clinic for the invite and for bringing me out to discuss with you a little bit of wills and estates. I see some familiar faces in the audience from last week, and I also see some new faces, so that's great. Thank you for being here with us today. And so what I'd like to do for the people who were not here, and even maybe for the people who were here but maybe fell asleep because my voice was monotonous, let's give a little bit of a recap as to what we discussed last week, and then build on that as we navigate the process. And so to recap, we began speaking about advance directives, and these were documents that you could draft that were during your lifetime. And the important documents we spoke about were a power of attorney. And there were three types of power of attorney documents that we spoke about. One was the continuing power of attorney, and then also the non-continuing, right? The one that was for a more specific time, as well as the power of attorney for personal care, all right? And we discussed how important these documents were, how powerful these documents were in the sense that, in essence, you're empowering someone else to sort of step into your role as it relates to your property and your finances and your personal care. Remember, we used the analogy of that you've all seen in movies where the person is in a coma and then another person is going to pull the plug on the machine that's keeping them alive, right? And so that's an extreme example, but we do see how that relates to the POA for personal care. Also, we began going down the path of a will, and we discussed why a will would be important to any individual, right? We discussed intestacy, or dying intestate, which is dying without a will, and all the ramifications that could happen in those situations, in those scenarios, and that seemed to garner a lot of questions from the audience. But I think we built a pretty strong foundation from the viewpoint of why a will was important, right? And then, of course, we'll transition into today, where we've already discussed the importance of a will, but we'll more delve into sort of what a will is, what is a good idea, the type of clauses to put inside of a will, and the ramifications. And we'll also deal with trusts, which also are included in wills, and all of these dynamics and issues that are sort of legalese, sort of need a little bit of fleshing out, but we'll tackle that today. Were we going to recap that video at this point, or?
Hey, so y'all can do all this renovation work and you still can't call the estate planner that I connected you with?
See, we knew you were gonna ask, so. There you go.
Y'all wrote your will in pencil?
Well, I had to erase a few things because Jerome pissed me off.
Mom, Dad, this limp, loose leaf of paper does not qualify as estate planning. You actually have to go through lawyers.
Hey, Molly.
So we remember that, right? And a lot of dynamics happening there. Obviously, the family who thinks that, by handing her a piece of napkin written on a piece of paper, that qualifies as a will, and she's explaining to them that's not really how it works. Also, there was a question from last week that dealt with sort of how do you bridge this topic with your family members. And so I tried to give some advice as to sort of how to do that. And then obviously, you saw the section where she wants to write one of the kids out of the will. So you have all of these dynamics playing with each other when we're thinking about navigating in the wills and estates process. But the first question to ask is, what is a will, right? And so as we said, in contrast to the power of attorney, which is sort of a form of disability insurance that helps you while you are alive, you can think of your will as a form of life insurance, right? Which takes care of your loved ones after you pass away. Remember that there's that interplay between the POA, which deals with living, and the will that deals with you when you pass. A will is a document that sets out person's wishes and directions with respects to the disposal of their property after their death, right? And so the person who is making the will is called the testator, and when we sign the will, we're saying that we execute the will, okay? So you have what is a will, and then now who can make a will, right? So to make a will, you must be mentally capable. And what that means is that you understand why you're making the will, the nature and amount of property that you have, right? Also, which of your dependents should be included as beneficiaries. Okay, so all of these things you need to fully appreciate and understand. I brought the example last week, even in dealing with power of attorneys, and the same is true with regards to wills, that when I'm assessing clients that come in, I'm really looking for capacity, right? Because you have scenarios where you have older segment of the population, older clients, and they have their relatives that are coming in and sort of telling you and leading the conversation as to what the person wants, and that's not really how it works, right? I need to assess what you want in your will, or what your will is, and if you understand the breadth of everything that is included in your estate. So the reason why we go through all of those things is because your will may be challenged if you make a will when you're not mentally capable, right? If you don't include dependents, and a dependent would be a person who you're supporting financially before you died, or a person that the law says that you must support, right? You also must be at least 18 years old to make a will, and there are exceptions like there are in many other instances with regards to the law, right? So those exceptions are if you're legally married, if you're a member of the Canadian Armed Forces, and if you're a sailor. Okay? And generally there are 3 formal requirements for a will to be valid. You will recall these from when we discussed the POA. They're very similar, okay? And so these formal requirements are, again, the acronym WSW. The will must be in writing, the will must be signed by the testator, and the will must be witnessed by 2 witnesses, neither of whom can be a beneficiary named in the will or a spouse of such beneficiary, right? This is for obvious reasons, right? If you required one of the witnesses to be a beneficiary, there's the conflict of interest that's at play there, right? And so you really want to, you need to, as a formal requirement, to get a completely detached, non-beneficiary individual who won't have that conflict of interest, right? Because we're trying to prevent against fraud or undue influence or duress. Okay? So, what should be included in a will? Okay? And now, should maybe is a strong word, right? These are things that are generally included in a will if they're applicable to you, right? Some of them are you absolutely have to be in there, but some of them are just based on your circumstances. Okay? So your will could include beneficiaries. That's important, right? There's the reason why you're drafting the will. It's to dispose of property and have it go to another individual who is a beneficiary, right? A list of your assets and debts, custody and guardianship clauses, and it needs to outline or nominate trustee or executor. We'll get into all of these in much more depth. All right. So moving forward. Oh.
I love you. Okay, so let's just get back into it. So we've covered beneficiaries.
Oh, and Kiki sent you an email. She wants all of my linens and my anklets.
Yeah, I got that email. I also ignored it. So why don't we just go back to balance sheet?
Balance sheet? What's the balance? Y'all know you get the house.
We made sure of that.
We still gotta discuss the specifics, like how are we splitting the house, and what's in your set, or do you have a Roth? And if mom has another stroke, where does her money go?
Ooh, we have not talked about that.
Y'all want some tea? I'm gonna make some tea.
It sounds like a lot of questions which lead to the same thing. Just split whatever there's left evenly. I don't care. I'll be dead.
David.
Dad.
You know, Mr. Carter, I know what you mean. You know, but the bank's gonna need an actual dollar amount so they can paint an accurate picture of your financial assets.
So how big is the 401k?
I had to borrow against it to cover your mom's medical expenses. There's not much left.
Wait, what?
What happens if mom has another stroke?
I don't like this conversation.
We're out of tea. I don't know if we ever had any tea, but I'm gonna go to the store.
I promise you, Mr. Carter, nobody likes talking about money. And when you see your whole life on a piece of paper, I mean, it's sobering. I can't tell you how many of my clients I've seen open mouth sob because all they have to pass on is an old Nissan Sentra. Manual transmission. But we're professionals, and I've seen every scenario under the sun.
I just don't like seeing how little I have to leave my family. I mean, I worked 50 years and it feels like I've got nothing to show for it.
That is not true.
Dad, you gave us love. And that's what's most important. All of this is just things.
And, you know, it's never too late to start saving for your grandkids. I mean, we could hook you up with a special savings account today. All we have to do is call the bank, and you know banks love getting calls. Answering phones, always like, hello?
They do be like that.
Look, we can just take it one step at a time.
You trying to make a withdrawal?
Right, so as you can see, I mean, they made sort of light of it, but there's so many dynamics that went into that video. Obviously, the difficulty in discussing some of these topics, right? You're putting your life on paper, right? Not a lot of people like to do that. People don't, it's a morbid topic. We spoke about that last week as well, right? And so, but it's important, as you saw, the interplay between the family and the parents, right? That it's important to outline these things and list them. And you don't want to go through the process because it reduces your entire life onto paper. But we discussed last week. Remember, we used the "you're richer than you think" that Scotiabank has made so popular. I think there was a question in the audience that said sort of like, well, why, if I don't have anything, why should I draft a will, right? And so you first of all, when you do reduce it to paper, you sort of see that there is a lot more that you have going for you. I made the analogy of, you know, anybody who owns property in the city of Toronto is sitting on a lot of money, right? Because of how property values are, right? But even if you don't, again, this is a document that you're drafting for when you die. And you're not necessarily going to die tomorrow. You can die 20 years from the time you wrote, 30 years, 40 years, 50 years, right? So during that time, you could accumulate even more assets and wealth. So even if you feel like you have nothing at this time, who's to say you won't have something by the time your affairs need to be in order? And so that was a great sort of clip to illustrate all of the dynamics that go that are at play. So again, in the line of things that should be included in a will, one of the things that we see frequently when I'm drafting clauses in wills is this custody and guardianship clause, right? So obviously this is relating to people who have minor or dependent children, right? You want to make sure that you make arrangements for them after you pass away. So a custody clause section should be included in your will in which you outline who will take responsibility for your dependent children. And so obviously issues that you want to contemplate when you're drafting these clauses are things like decision-making responsibility, which is the new phrase for custody, what you would have heard historically as custody, nominating a trustee, and we'll go into that into more detail, guardian of property, and children with a disability, right? Because when we're talking about dependent individuals, all of these are sort of in that basket, right? There's a note at the bottom here that says, you know, in the event, okay, so sorry, typically what ends up happening is obviously if you're married, if you have a spouse, and you were to die, the child would, it's still the custody and guardianship of the remaining spouse, right? But in the event that the other parent cannot take care of your child or children after you die, for whatever reasons, maybe it was a catastrophe and both of you died at the same time, right, untimely, you can appoint a decision maker in your will to take care of your children for up to 90 days, right? If the person would like to continue to look after your children, they will have to apply to the court for decision-making responsibilities before the 90 days has passed. So all this means is that the custody and guardianship clause that you draft in the will, right, has a shelf life. It's not that you draft this in the will and this person is not automatically the guardian for your child forever, right? What it does, it sort of is a placeholder and buys you the time that you need, 90 days, approximately 3 months, right, to now apply to take official guardianship of the dependent child. So that's just food for thought. They don't think that because you have the guardianship clause in your will that the buck stops there. No, there's another process to go, and the person that you nominate as the person that's going to take care of this dependent child or children should have knowledge of that and act accordingly. Okay? And of course, the interplay with that is, before we move on, is that also another clause you'll put in a will is to provide for dependent children financially, right? This is another form of a trust. And we'll go into trust later on, but while we're on the topic, is that guardianship is one thing, and then you also want to sort of provide money for this child who's going to be, in theory, living a lot longer after you die, right? And so you might want to create the trust inside the will that will put conditions as to how you want the property to be dispersed. One of the issues you see happening is that if you were to pass away and you had a very young child, a 7-year-old, 6-year-old, right? You don't necessarily want a 6-year-old coming in into $200,000, for example, right? And so what you would do is you'd set up a trust that will pay for the normal expenses over that child's life, school, food, clothing, right? And because obviously at that point, having anybody that young coming into that much money would be an issue, right? And so you have a trustee that deals with that. Again, we'll go into depth with trust a little bit later. So moving on, again, these are just things that you want included into your will, and another key, probably most important one, is disposition of property, okay? So you want to put in a disposition, oh great, we have this this little comic here. It says the father is there and he's showing his son the sort of the lay of the land. He said, one day, son, 60% of this will be yours, right? And so that's sort of a cold way of sort of trying to, and the kid is sort of like bewildered. He doesn't know what's going on. And so it's like you don't really appreciate these things, I guess, when you're younger. But basically, he's showing him his splits of what is 60% of this, right? It's like hard to even tell, right? But that's sort of what the law reduces it to in these scenarios, right? So disposition of property. You want to add a disposition clause, which is an instruction regarding how an estate is to be distributed among beneficiaries. Okay, this is essential. This is an essential clause because the will is not considered a will unless it contains some sort of disposition, right? What does that mean? There's a reason why we're drafting these documents, right? It's not just because we want to. It's to, again, take assets that you had that are contained in your estate and direct them to someone else who is the beneficiary, right? And so within this disposition of property, you have a whole bunch of things that are incorporated into it. I don't know if you remember back to the video where she had a little piece of paper and there was like artwork, I don't know, like the fine china, all of these things that she thought were important, right? But that is her property, right? And we spoke last week as to how sometimes these forms of property are very valuable and sometimes it's more sentimental value, right? And so we start off with the big ticket, right? The real estate. Okay, and again, it's like what I said. Even if you don't own property or real estate at the time of the preparation of the will, you may own it in the future, right? And if a property is jointly owned with right of survivorships, it will pass outside of the estate, meaning that its distribution is not managed by your will. What that means is that typically, and it's not always the case, but normally what happens is that when you buy a house and you have a spouse, you guys both go on title. Both of your names go on the title. And normally it's in a legal format that has rights of survivorship, which means that if one of you were to pass, the property right automatically vests in the other spouse. Okay? And so those things are said to pass outside of the will, right? However, there are situations where that's not the case, right? Where you have a property that's registered as a tenancy in common. Okay, and that means that you have separate rights in the property, and you would have to, upon your death, have instructions as to where the remainder of that property goes. Okay, and if you're not sure about any of this, you can check with the lawyer who facilitated your real estate transaction, and then it should be written on your deed, if not speaking directly to the lawyer. Okay? But remember, we said that the real estate is one of those big ticket items that you really want to account for when we're talking about the estates process, because it's probably going to be the bulk of the value of your estate. But that's not the only type of property, right? We have another form of properties, personal effects and household furniture, right? Any personal property that is given as a gift must be retained by the estate trustee until delivery to the beneficiary, all right? Other personal effects and household furniture, furnishings, appliances, and equipment can either be sold or distributed to the beneficiaries. Okay, and you'll see these clauses built right into the will, right? That empower the estate trustee, which we'll talk about in a few minutes, right? Or give them instructions literally as to how they want them to do it. So it can either be open-ended. My trustee can do whatever he wants: buy, sell, trade, get the maximum value of these things like the couch or the fridge or things of that nature that have value, right? Or if it's more of sentimental value, again, the state trustee holds it and keeps it whole until it's time to deliver it to the beneficiary. Moving forward, other types of property. Vehicles. I think in the videos she mentioned the Nissan Sentra that was manual transmission, right? So many people might not want that car, but other people own, vintage Rolls Royces and things of high value, right? And so either way, where the deceased owned a vehicle, it is the estate trustee's duty to take possession of it and keep it in a safe place until the time comes to transfer it, right? Again, you're maintaining the value of whatever the property is. Cars are an important one, right? You don't want to leave it outside, subject to the elements, or someone could break into it and steal it. Especially if it's a car of value, you want to make sure you take care of it, right? Another form of property are business assets, right? Business assets of the deceased, whether owned as a sole proprietorship, shared in a partnership, or by way of shares in a private corporation, are assets of the estate. So sometimes we think of physical things, a phone, a couch, a fridge, an heirloom as property, but also the law is telling us that business assets as well, right? So shares in a company, right, which are sort of not a concept that most people think about, but those are they all go in to and provide the bulk and basis of your estate. Now, another thing that should be added into the will, and all of them have to be, or it will be nominated for you, is a trustee or an executor. Now, sometimes these words are used interchangeably, right? I think in the wills I draft, I just pretty much say that when you hear trustee, executor as well, or executor, trustee, they're all interchangeable, right? But technically they have different roles in terms of the process, okay? And so we're going to really delve into this. It's important to name an executor in your will because they will be the person in charge of taking care of your estate. If you do not choose one before you die, the courts will be in charge of appointing an administrator to execute your wishes, okay? And that person that they nominate, and remember we spoke about it during intestacy, may not be someone that you wanted to nominate for this role, right? So responsibilities of your executor include things like paying off estate debts, recovering money owed, paying your final tax return. Remember we spoke about death and taxes, they get you coming and they get you going, right? Distributing assets and gifts to your beneficiaries, and handling your funeral and burial wishes, including the organization of your funeral or cremation. And again, this is all built into the language of the will, right? Depending on what you want, you can put it right in there or speak to your trustee or executor in order to have your final wishes adhered to. So again, the executor and the estate trustee are two different roles, but the same person can fulfill them, right? The difference is that the executors take care of the entire estate administration process, and once that is completed, typically in between 12 and 18 months, their role concludes, right? can move to the next one. So that's, again, their role concludes after they bring it up to the part of distributing the estate. However, a trustee would handle the trusts. These are assets that are being held for any beneficiaries and work with the beneficiaries named in that trust. Remember, I stated before that if you have a minor child, for example, you want to set up a trust for the payment of that child throughout their lifetime. So whereas the executor role sort of ends once the estate has been distributed, the trustee role, in theory, can go off into eternity, right? Because if you have a young child who's 7 years old and the trustee has to be the one paying out a monthly or whatever the case may be, whatever the instructions are, that role is obviously reoccurring as long as the child is not of age, right? And then once they get to a certain age, whatever age that you name in the will, then they can handle their affairs on their own, okay? So it says right here, if you have minor children, when you pass away, many wills trigger the creation of what is called a testamentary trust, which holds assets in trust until the age at which you stipulate in your will. A trustee manages that trust. Again, tax returns. That's every year the government gets you have to file these returns. Releasing funds for the child's care to their guardian, etc. While the executor's role ends as soon as the estate administration process is complete, a trustee may act in that role for a much longer period of time. Now, before we move on, other roles, and this is why it's very important if you're ever asked to be an estate trustee, is that it's a very serious role, right? Filing tax returns, executing the estate, right? Sometimes you have to communicate with any of the beneficiaries on a consistent basis to keep them happy. You can think about if there's a family of 11 individuals and they're all thinking they're going to get some payout, you know who they're going to be calling every night is going to be you, right? Like what's happening with the process, what's happening with the will, what's happening with my payout, right? And we already said this process takes a year and a half if you're lucky, right? And so you can see sort of how that's going to be a problem for you as the executor, which is why many people source it out to lawyers, people like myself, right? Just to stand in, because many clients come in and say, I don't want any part of this. I don't want to have to deal with it. I look like the bad guy or bad gal, and it's not something that I really want to have to deal with, right? It can be time-consuming and stressful, and so it's very important to choose the right individual who is built for it. And as well, you also name a contingent or a backup executor, just in case something happens to them, or they decide one day that they don't want to do it. So many times you have at least two I recommend to clients. They might have their son, but maybe if you have a son and an uncle or whatever, have a contingency just in case that executor falls out. Okay. So, moving forward, probate. Now, probate is another one of those words where if you weren't involved in these processes or didn't go to law school, you'd have no idea what it was. I had no idea what it was before I learned what it was, right? And so probate is the process by which the courts formally accept a will, or, if the deceased did not have a will, appointing someone to act on their behalf. Okay, so again, we're going down the sequence now. We've decided that a will is important. We've shown things that we need to add or should add into a will, right? And now we're getting to that process where we have the will now and we sort of want to authenticate it or validate it. And the process by which to do that is probate. Okay, and so there's situation where your will must go through probate, and there's other situation where it might not have to. Okay. So your will must go through probate if you own property, a home. So for all of you homeowners out there, if you have an estate and you've drafted a will, it must go through probate. No ifs, ands, or buts about it. Okay? Also, another way that it must go through probate is if a bank or other third party requires a grant of probate for assets over a certain dollar amount. Right? So you might have the bank that's involved that is paying out on an estate, and they just require it to go through probate. Like that's their policy, and they have no ifs, ands, or buts about it. That's the way they want it. That would be another reason why it must go through probate, okay? Situations where your will may not need to go through probate are examples like you have a small estate. Many banks will release assets under a certain dollar amount, like was mentioned before. If a financial institution agrees to waive a grant of probate, they might require additional protections, like for you to undertake or indemnify in an affidavit, right? Did you have a question? Or,
sorry, she was saying something to me again. Going back, what approximately is the dollar amount for a bank or a third party requires a grant probate for assets over a certain amount? What's approximately usually the amount that they usually require?
we're going to go over the breakdown of the price in future slides, okay. Right? But that would be up to them because that's their requirement, right? Like ballpark figure, 100,000, right? But there's no set because it's an individual institution, right? And so that's not required by law. That's like Bank of Montreal saying that we have a payout, that we have a life insurance policy or some sort of beneficiary, and you must go through probate to indicate that the individuals who are designated as beneficiaries under the will are the ones who are designated as beneficiaries under the will. Was there another question?
Yeah, I'll add on to that.
Yes.
In my experience, I've dealt with it as a banker before. It can be as low as like 20,000. It depends on your relationship, which, just like you said, it's individually decided by each financial institution. But it can be as low as 20,000, as high as 100,000.
Yeah. And sorry, I know I'm supposed to repeat the question. The question was the individual wanted to know that is there a specific dollar amount when we're talking about the ones where the third party or the banks are requiring it? And the answer was that it just varies as to the institution. Okay? So we're in the list of situations where it might not need to go through probate. If you are a First Nations member who is a resident of a reserve, if you used multiple wills to separate assets, and the second will does not require probate. We might touch on this a little bit later, but there's a possibility for people who have different types of assets, specifically business assets, to write a secondary will, right? And so you have a primary will of things that would have to pass through probate, which is at your house, right? And then the secondary will would deal with, you see this a lot more with people who have large businesses, and they want to get a tax break on the probate fees. They want it outside of the estate administration tax process, and so they'll write a second will for the assets that don't have to be a part of probate. So the rule is, if you don't, just to touch on it, if you don't have a secondary will, all of it will be lumped into the primary estate, right? If you draft a secondary will, you can shield it from those probate fees. So for all you people who are out there with big businesses like Bill Gates, this is the way to get a tax break, right? So probate, you sort of go through the classic what, when, where, who, and how, okay, when we want to understand the process, okay? So what is probate? We touched on it already. When does probate happen? So probate happens after someone passes away, obviously, and involves filling out an application for a grant of probate, okay? Where does this process happen? Typically, your executor will apply for a grant of probate in the province where you lived at the time of death. We are in Ontario right now, so that's what we're dealing with, right? Who handles the probate process, okay? If you have a will, your executor handles the probate process. If you do not have a will, the court will appoint an administrator who acts in the same role as an executor. And again, this goes back to the intestacy, another reason why you want to have a will, so you decide who is your executor and not the courts. You had a question there? Yes.
Is whoever they appoint, would it be someone within like your family, community of people, or they just choose Jeffrey?
You're talking about the courts?
Yeah.
So the question was, who do the courts appoint, right? And so, yeah, it's not random, right? If any court with sense is not going to just pick random, but it could be. So a scenario where you have an individual who has a massive estate and have no next of kin, right? And a loner has no friends, right? Now it becomes a little bit more difficult, right? So normally in those situations, the court would just choose a lawyer. They'll have, in practicality, in real life, they have a list of individuals they refer it to and a person that they trust, right? But if it was a situation where, the court could ascertain, or the argument could be made that this person is their brother, they handle their finances, he was their accountant or their lawyer, he's a good candidate, the court would be petitioned to make that decision. They're going to make a common sense decision, but the bottom line is it won't be your decision, right? They're going to make that. They're going to make that determination. But to answer your question, it's not like they just pick a random segment of the population, because the courts also want it to be someone who is competent and who has the ability to be the executor for the estate, right? They don't want confusion. But that's a very good question. So we're right there where we said the court will appoint an administrator who acts in the same role as an executor, right? And they wouldn't do that just offhand. They'll try to make sort of sense of it. So someone had mentioned a little bit sort of the fees that surround it. And so Ontario uses an increasing scale up based on the size of the estate. The percentages increases on the estate amounts in excess of $50,000. So the way it's broke down is there's no probate fees, right, in Ontario if the estate is under $1,000. So they give you a break. But of course, you can sort of guess how many times an estate is under $1,000, right? Not very many times, right? Like I said, even people who think that they don't have assets, you typically can get over that threshold pretty easily, right? A cell phone is probably $1,000 these days, right? No flat fee if the estate is under $50,000, and 0.5% per $1,000, right? And then the next, if your estate is over $50,000, you automatically have a $250 flat fee, plus 1.5 per additional $1,000, right? Yeah. So you can see it adds up, right? And you can also see now why, when we spoke about the secondary will, why people with substantial means want to isolate that amount from probate at all costs, right? Because you could be talking about, your personal property is only $500,000, but your business assets could be $10 million, right? And so when we're doing the math of 1.5% per additional $1,000, when you're talking about $10 million, it really adds up. You had a question?
Yes. For the probate process.
Yes. Literally, you file a piece of paper and hand it to the probate office, and then they go through the process of validating your will, right? So all it is a validation of the will process. It's a glorified way of just saying that, right? So because you could imagine what could happen, right? Like someone dies of substantial means, and 15 different people come to them and say, I have the will, and the will says that all of the money is supposed to go to me, right? And so what probate is a process by which we're validating the veracity of the will, right? And so we sort of touched on this before with regards to, obviously the most recent will, because you'll have a situation where people will have multiple wills. That's not multiple valid wills, but you drafted a will when you were 16, and you drafted another one when you were 35, and then you drafted another one right on your deathbed, right? Well, the one that you drafted on your deathbed is obviously the right one, but that doesn't make the other ones just poof and disappear, right? They can still exist, and so it's just a glorified way of validating who the estate trustee is, who the beneficiaries are, and what the valid will is. Did I answer your question? Good. Any other question? No. Okay. So so that's the food for thought with regards to the breakdown. Again, the tax man gets you coming and gets you going, right? And so even on your way out, there's that last tax you sort of got to pay. Trusts, another very important integral part of the wills and estates process, right? We have our little comics are back again, and they're at a party, and the man says, "I have major trust issues. My father didn't leave me one," right? And so, you and me both, man. I can handle that. You always hear of the situation where a trust fund baby. That's where this came from, right? It's pretty much your parents had means and they set up a trust for you, and this thing just pays you out either upon their death or sometimes while you're alive, depending on the nature of the trust. And so we'll delve into this section. Sort of some of the trusts that we'll discuss aren't necessarily typical in wills, right? And some of them are absolutely, you see them all the time, right? And so we're going to flesh out sort of what the trusts are and what they do and why it's important for you to add them in your estate. So a trust provides a mechanism for a person, the technical term is a settler, to provide property to another person, the trustee, for the benefit of a third person. So again, you have the individual who's contemplating the trust. So let's say that's you, right? You have the person you want to be your trustee, right? And then you have the individual you're setting the trust up for. Typically, you see it for children. So let's say you say for your child, right? That's the beneficiary. While imposing certain restrictions and conditions over the property. The property is held and administered by the trustee. Okay? And again, because we're in the realm of law, right, there's always these hoops you got to jump through, right? And so a trust must have 3 characteristics or certainties to be valid. And we're going to flesh this out a little bit, okay? And so it has to have the certainty of intention. All right? So the settler, or you, must disclose an intention to create a trust. These things can't just happen by accident. It's not going to be like you had a conversation one day and all of a sudden, oh, that's a trust and you owe me money. No, right? It has to be very deliberate, okay? It has to have certainty of subject matter, okay? There must be a property vested in the trustee, right? So I, the settler, must be handing some sort of property interest into the trustee to manage, right, on behalf of the beneficiary, right? And certainty of objects. It must be possible to ascertain the beneficial owners of the trust, either specifically named or by class, right? What does that mean? Okay, so sometimes it sort of seems like there's no difference, but there certainly can be. So if you want to set up a trust for your children, right? Well, obviously, if you have children, you can ascertain them by name, right? You can see if you literally write their name into the trust, right? But you might want to set up a trust for your unborn children, right? And so that's where the class comes in. You're going to name it by a class. There's an area of law that sort of talks about I don't want to mention this because it was so horrible to go over in law school, but you sort of can't create scenarios that cannot vest within a certain amount of time, right? And so you got to be very careful when you're dealing with the class issue, right? You don't want to limit it. Even if you have one child, you don't want to limit it to just that one child. What if you have another child, right? And you don't get to redraft your will. So you name Billy, right, on the day you draft your will, but you don't name Susan, who you're not going to have for another 3 years, right? Well, you would put Billy, and then the language would be, or any other children that I might have at the time of my death, right? And that keeps the class open, and Susan doesn't feel like she's been left out when the time comes, right? And so you have to really be careful in how you craft it in terms of setting up the trust that you want the payout to be for everyone, or maybe you don't want the payout to be for everyone, right? and that is another situation where you have to be very clear in your language. But you must have these 3 characteristics in order to have a valid trust. So in Canada, where we are, there are 2 types of trusts. Testamentary trust, and that is created as part of a will and comes into effect only after the testator, settler, you pass away. Okay? And an inter vivos trust, which is established while its creator is still alive. Remember, we spoke about the dynamic of, in some situations, if you're a parent, you're going to be taking care of your child while you're alive, obviously, right? And so there's not necessarily a need to set up a inter vivos trust while you're alive, because you're pretty much going to handle all of their finances and whatever they need, right? And so you might only need a testamentary trust, which only kicks in when you die. But some people don't do it that way. Some people set it up while the person is still alive, right? And there are other implications with regards to that. But sometimes they just want that settled before they pass, or they want to see the sort of the benefit, like, I'm taking care of my child. Some parents want to see that, and so that there's an option for that. So which one of these that you choose is dependent on what you intend to do with it, right? If your primary concern is to ease the transfer of assets to your heirs, right, while sort of taking the burden off of your estate tax burden, then a testamentary trust is probably all that you need, okay? On the other hand, if you want to use the benefits of a trust for your business and your family during your lifetime, you will want to establish an inter vivos trust, okay? So, we mentioned the sort of the two categories they fall under testamentary when you die, inter vivos when you're alive, right? But then these are different types of trust under those subheadings, right? And there's a bunch of them, all right? Some of them are more relevant to the wills and estates process, and some of them you don't really see as much. But we're going to go through a whole bunch of them to sort of give you a flavor as to what these different types of trust will look like, right? So, first one, and we'll go through this pretty quickly, alter ego or joint partner trust. This is an inter vivos trust while you're alive by a settler who is 65 years or older. So specifically it relates to that age dynamic, right? Family trust, as you can see, it can be either or, used to split income within family members, usually dealing with tax planning strategies. Henson trust, this one is pretty big, and you see this one a lot in wills. It can be inter vivos or testamentary and used in estate planning for disabled individuals. So with a Henson trust, if you have a dependent that is disabled, as you know, you can get disability payments from the government, right? But the government will not give you disability payments in certain circumstances, okay? And one of those circumstances could be your disabled child coming into a bunch of money from a payout from an estate, right? And so in order to shield that individual from losing their disability payments from the government, you create a Henson trust, right? And that shields and insulates, as far as the government is concerned, they never got that money from the estate when you create a Henson trust in the will. And these trusts you see quite frequently, as a matter of fact, okay? Testamentary spousal trusts, again, allows property to be transferred to a surviving spouse, including a common law partner, when an individual dies. Moving on. And that one was important because remember we had discussed, I didn't want to go too much into family law, but we had discussed the difference in terms of how the real estate property was handled as it relates to married couples in contrast with common law individuals, okay? So it's before we get to the Q&A, a couple of things we spoke about with regards to the POA is the same thing we speak about when we're talking about wills, all right? It's a very good idea to review, if you already have a will, to review it when any major life changes happen, right? Whether you get married or have children or, come into some money, right? You sort of want to do a very good review of the will, and you might have to just get a brand new will, right? Draft a brand new will. Also, we spoke about safekeeping of these documents, right? typically what I do is when the client executes the document, I give them the option of leaving it with me, right? That's probably the safest way to do it, right? Because we have certain mandates from the Law Society as to how we're supposed to take care of these documents, right? But you don't have to do that. You can take the document yourself, or maybe you didn't have a lawyer who drafted this will. Maybe you drafted it yourself, right? And you want to keep it in a place, I said last week, a fireproof and waterproof safe, right? Because you really want to keep that document in good condition, because if it's destroyed, then there could be obviously issues with regards to litigation. The person who had the last will is going to claim that that's the best will, and all manner of problems. Okay? But right now I want to open up to any questions you may have.